Good morning and welcome to the BDO Thames Valley seminar on international home working. It's great that so many of you are here today. So I'm Neil Brackstone, the local head of tax for BDO in Reading, and I'm going to be your chairperson today. I'm joined by Lee Caro, one of our global employer services partners, who's going to discuss the employment tax and social security considerations of international home working. We've also got Richard Duval, who's a partner from IBB Solicitors, who's going to share some thoughts on employment and immigration. And then we've got Carol LePage, one of our business tax partners at BDO, who's going to take us through the corporate tax aspects of the topic that we are covering today. So before we move to our speakers, I'd like to spend a few minutes just to set the scene in terms of the topic we're going to discuss today. So I think we'll first start with a poll. Which we just get a sort of sense of what stage businesses are in their thinking on this topic. So if you could please just sort of answer that would be good. And we can just quickly, as a group, look at what the results are. Okay, should we publish the results of the poll, please? Okay, so just a reasonable split there across at least the main four categories there in terms of the thinking that's happened already around that. So that's interesting. So thank you very much. So next slide, please. Thank you. So the last year has been like no other, and we've known before, and this timeline does not show really any surprises or anything we don't all recognise. Since just under a year ago, an unprecedented number of people have been working remotely or mainly from home. And we've had lockdown in March last year, where literally overnight many people moved to home working. I personally have not been in one of our offices since about sort of 16th of March last year. I think it's testament to the IT teams around the world that we were all able to do this with relative ease. So there was some relaxation around the rules in the summer before obviously the tightening that we saw of the social distancing rules and restrictions in the autumn to what we now have today. So next slide, please. Well, the pandemic has accelerated the pace of some changes that was already happening before C19 came. So that, you know, the growth of online shopping and food ordering, online exercise classes, and remote working, to name but a few. It's also disrupted work patterns and where people work. People, because of the pandemic, have returned to their home countries for personal or well-being reasons. And it's anticipated that after the pandemic, international remote working will continue more than it ever did before. And this will bring with it a wealth of economic and well-being opportunities, but also what can be classed as compliance risks that businesses need to think through so they can develop remote worker policies and integrate this as part of their future business strategy. And having a strategy will help both employers and employees maximize the opportunities that this change brings, from more flexibility for employees through to a greater choice of talent for business. And in determining this strategy, there are a plethora of considerations, and our webinar today is going to concentrate on the income tax, corporate tax considerations, as well as some of the legal ones. And as you can see on our next slide, please, you know, under each of those headings, there are a number of topics to consider. Before I hand over to Lee, who's going to be our first speaker today, I wanted to say that we've had some time for questions at the end. So many of you have been sort of kind enough to send some of those through. So we'll address some of those, as well as some of the live questions that that we can have during the session today to keep our speakers on their toes. So therefore, please submit any questions as we go along through the chat function, which should be at the bottom of your screen, and then we'll take the time at the end to answer as many of those as that we can. So what we'll also do after today's presentation is circulate a recording of this webinar, and will also be posted on our local website. So on that note, I'd like to hand over to Lee to kick us off for the day in terms of the speakers, please.
Excellent. Thanks very much, Neil, and good morning, everyone. I'm Lee Caccaro. I'm a partner at BDO. I'm going to be covering off the employment tax and social security aspects of this, and just to also thinking a little more broadly around the employment piece as well. So Kevin, could we jump on just a couple of slides, please? Perfect, thank you. So I thought it would be a good idea just to start thinking about the categories of remote worker that we have. And I appreciate, obviously, today we're mainly focused on international home working, but do remember there is a concept of sort of domestic remote working as well that's going to increase. As Neil said, this is going to become more prevalent. And that's especially true and a consideration that's needed in countries like the US, where you might have cross-state lines where people are working cross state lines. You have, for example, US state taxes to consider. And I think just that third category I've got there, the international remote worker, that for me is where we're going to see the biggest increase. And that's basically what we're seeing at the moment. It's where you're remaining working for the company you were working for previously, and normally you'd be in that country as well, but you've asked to go and work overseas. So for UK businesses, you've got some of your employees now working remotely overseas, and vice versa. But what I also wanted to mention just around this is that don't forget these other categories of remote worker won't fall away. They'll be there as well, especially when travel fully opens up again. But it's this remote working piece that we're going to mostly be focusing on in terms of international remote working. Kevin, can you just move on to the next slide? I do love a quote, so I've dropped a quote in here, and I think this is very true, and I can certainly relate to this. I think we can all agree you can't build an adaptable organisation without adaptable people, but generally people only adapt when they have to or when they want to. And I've started with the when they have to piece with this. I think we certainly early on at least went through the have to adapt phase. Just moving on, Kevin. So where have we got to, and what do we need to do? Well, I think a good starting point for all of this is you need to think about what works for you as a business, actually. And for example, I think probably for the only time in all the time I've been advising companies in this area, which is 20 plus years now, it's very much been the people aspect driving the corporate decisions. And that's because this way of working was imposed upon us early on. You know, I think we've gone through what I'd consider three phases. There was the short term back in the spring, where there was a very quick lockdown. Businesses were thinking very operationally, which was understandable. We then moved into the medium term phase, sort of the early summer through to the late autumn, where I think businesses had mostly got their head around this remote working, realised it was here to stay, and actually started to think about what this is going to look like going forwards. And now I think we're into what I like to refer to as sort of the Buzz Lightyear phase, the infinity and beyond. Actually, this is going to be the new way of working. Employees largely like the flexibility, and actually employers can see a lot of the benefits of this as well. So what I'm seeing now, and probably over the last, I would say 2 or 3 months, is I'm really having those conversations now with my clients around planning for this and thinking about reevaluating the way work is being done, reevaluating how businesses are operating. But actually the key message here is to sort of take back control as a company and actually do it from a business decision perspective now. So just moving on, Kevin. One of the first things, if you haven't already thought about it, you're going to need to think about is your policies and procedures. They probably were absolutely fit for purpose, of course, back in March 2020. And we're now in a position where actually things have changed quite quickly. And you'll probably find that your policies and procedures in certain areas, at least, aren't fit for purpose anymore. You do need to think about how this new way of working and being more flexible should be filtering into your policies and procedures and the wording in there. I know Richard, of course, will cover some of the legalities around this, but some of the things to think about is, where is the place of work now? It's usually in an office, but is home now the permanent place of work? Is there a permanent place of work anymore? Don't forget the employment law and immigration side of things. Some simple questions as well. I think mostly those of us that work in an office have been used to home to work travel, home to office travel being commuting. But will that still be commuting, or will it now be business travel? And is that expensible travel? I'm sure some employees, if they haven't already asked, will ask that question. If employees are going to start having the choice, the option to work in other countries, what about where the taxes and social security rates are higher in those countries? Who's going to be responsible for those countries? For the increase in tax and social security in those countries. Some employees again will ask the question, even though it's them that's made the decision. You also may have some things that are conferred on you in those countries that you may not even have thought about. Maybe some local benefit rights just because those individuals are now in those countries. Don't forget, you may have terms almost imposed on you as a business, and it won't be choice. So key things here are think about your policies and procedures, what works and what doesn't, and get that set in writing, because that's really going to help you with those conversations with your employees and thinking about what this is looking like for you now and going forwards. Also, just a last point on that, actually, and I kind of mentioned it a couple of slides ago. Don't forget, these policies and procedures also need to be flexed for the new domestic way of working. It's not just about international home working either. So just moving on. Tracking travel. This has been a key issue for businesses for a number of years now for multiple reasons. There's making sure that you've got the right work permits and visas in place. Again, something Richard, I'm sure, will touch on. You need to think about corporate establishment issues, which Carol will come to in her session, and some other things as well, health and safety, being able to contact your employees in the event of emergency, just knowing where they are, basically. So this is already key, and it's absolutely expected of you as a business that you will have a robust tracking mechanism in place for this. And some companies are certainly turning to sort of online tools or smartphone apps for this. We've certainly got a tool that we're seeing more and more of our clients using, where they want to be able to track in real time and have a system that works. I'd also say that there's already some mandatory obligations around tracking. In the UK, for example, you have short-term business visitor reporting. So individuals travelling into the UK that might be working into the UK on a very short-term basis, and I do mean on a business trip basis, there is already an obligation to report to HMRC at the end of each year for that. So there's already reasons to have these tracking mechanisms in place. I'd also just say that tracking is important from a share reward perspective as well. So if you have share plans or those types of plans in your businesses, I'll come on to this aspect in a little more detail, just in a few minutes' time, basically. So just moving on again, Kevin. Let's spend a few minutes on this, because I think from an employee perspective, this is where your compliance issues are really going to arise. And it's around the tax and social security, and I mean personal tax and social security. And don't forget, the employees will have a tax filing obligation, almost certainly in all the countries either they have come from or they have moved to. But for you as a company, it is around your payroll withholding obligations. And I'm going to deal with these separately. So let's just focus on tax first. Now, the general rule is tax is actually payable where an individual works. And in a worst case scenario, that can actually be where an individual has worked in a country just for one day. And I know from a UK perspective, the legislation is actually written that way. You can have an individual come into the UK, work in the UK for just one day, and that generates a tax liability on the income they earn for that day. Furthermore, there can actually be a payroll withholding requirement on you as a UK business on that individual. And that's irrespective of whether you actually legally employ them. And that's irrespective of whether you actually physically pay them. They may not be on your payroll in the UK. You may not employ them in the UK, but you as a UK business may well have that PAYE obligation. And that's replicated through other countries. And obviously you need to look at all the rules in the countries to establish what needs to be done. Do bear in mind that where there is a payroll withholding obligation, it's pretty much always on you as an employer to operate that payroll withholding. So you do need to know what you need to do in all of the countries where you've got employees. And that is irrespective of whether you have a legal entity or not. And Carol will come on to the legal entity side of things and whether you have established a corporate entity or not. But even so, some countries will say you need to appoint a payroll bureau anyway to operate payroll. Some countries have the concept, actually, you need to set up a payroll entity to operate payroll. So don't think just because you have no entity in that country, you don't have a payroll obligation. I think with the increase in international home working and the current arrangements as well, and that remote worker type individual, we're also seeing an increase in dual taxation, whereby you've got tax due in both the country you were in and the country you've gone to for a period of time. You've got this dual taxation, and you may have payroll obligations in both of those countries as well. And you need to think about how you manage that, both from the mechanics of actually operating payroll, but actually how does the individual deal with the cash flow disadvantage of having to pay tax in two countries on an ongoing basis? It's not equitable, and the employees may come back to you to address that issue. And I mentioned there just that final point about what if the tax percentage is higher in the country the individual has gone to. Again, they may well come back to you as the employer to see what you're going to do to help them with that. You do need to think about that as part of your policy. So moving on to social security, it is separate. Generally, it does go hand in hand with tax, but not always. You can be liable to tax in two or more countries and liable to social security in a different country or a combination thereof. So you do need to understand both the tax and the social security rules. And here you need to bear in mind that it's great being flexible for your employees if that's what you want to do and allowing them to work in other countries. But where they go and work may generate a social security liability in that country. And invariably, where there's an employee social security obligation, there's an employer one as well. And that can be a significant increase in cost for you. Actually, the UK is a pretty low cost country for social security. Employers is 13.8%. You could have employees going to countries that, like France, triggering up to 40%, Italy 37%, Belgium's at a similar rate. Nordic countries have very high social security, and so do some of the Eastern European countries. So do bear in mind that an unintended consequence of this might be an increase in social security costs for you as a business. Also think about some of the things your employees might want to consider, and that's sort of short and long-term benefits of paying social security. If you're paying social security in a country or not, are you entitled to healthcare in that country, the state healthcare system? Are you entitled to maternity and paternity benefits, for example? You may not be if you're not paying social security in that particular country. And then there's the longer term benefits to think about as well. Where are you accruing state pension rights? And I think last but not least, I probably can't do a webinar at the moment without at least touching upon Brexit. So Brexit has happened, as we know, 1st of January 21. There are EU-wide social security regulations and laws around this, and the UK was governed by those up to 31st of December 2020. We then had a very short, effectively, transition period for January 21, where the UK was looking to put in new detached worker provisions with what was or is now the EU, and now we're into the very new rules from 1st of February, where that provision is over, and we know which EU countries want to be or have elected to be governed by those detached duty provisions, the new ones through January, or those actually where we need to fall back on the underlying agreements that were in place. So what was a relatively straightforward set of internal EU rules has now become quite complex as far as movements between the UK and the EU is concerned. So just moving on to the next one. I said I'd touch on share plans. I'm just going to come back to this now. It is a very complex area, and tracking is key where you've got share awards. Basic rules again are you pay tax where you work, and let's say social security as well. So where you've got remote workers, expats, whatever you might want to call them, traveling through multiple countries, they may well be generating liabilities on their share awards where they're in all of those countries, rather, where they've got an award that is ongoing, where they're traveling through those countries. So invariably, where you've got people working cross-border, you've got liabilities in at least 2, if not more countries. And we're back to the point that there's almost certainly going to be withholding obligations where there's tax and social security due, and that's going to be on you as an employer to manage and get right. So tracking is key here yet again, and it's another area we're seeing an increase in the use of tools to sort of firstly, as I said, track the individuals, but then actually manage the liabilities and what's due in the countries when a taxable event arises. And we certainly, again, have one of those tools in place that helps you manage and calculate the payroll obligations. Do also think about the slightly wider obligations as well. So in the UK, you've got employment-related security reporting that needs to be done by 6th of July, and that's a company form that needs to go in. So you have that as well as the payroll obligations to manage. Just next slide, thanks, Kevin. So I appreciate it's been about a 15-minute run through. I could, like all of us on this webinar today, I could spend a half day or a day workshop just on my area. But I want you to think about some of the key actions you can take away and some of the key things to think about and consider now. First and foremost, we've got this 9 or 10 month period where you need to understand where your employees have been and what liabilities have arisen as a result of that, and maybe what you need to do to put that right and manage your compliance risks. So that, I would say, is the starting point to bring yourself up to date. In conjunction with that, think about that Buzz Lightyear phase. You know, what does this look like now going forwards and beyond? What do you want it to look like as a business? What do your employees want it to look like? And really engage across all the stakeholders within the company to work out what's going to work for you as a business. Then you can put that remote worker policy in place and have policies that are fit for purpose to govern this. Then it's an ongoing process, really. You've got to track your employees, something you should already be doing anyway, but even more so going forwards. Think about whether you want to use technology to do that and the best way to do that for your business. And then over time, just revisit it. What's working, what's not working, review and control what's going on, and then flex your policies again. We'll all find over time that we will need to continue adapting as we work through this. So just moving on to the final one, Kevin. And I just want to go back to that quote now. I think we've moved from the when we have to adapt to when we want to adapt. I think most of us as employees and as businesses now, we've embraced this way of working. It's a great way to work, we think. We like the flexibility. So let's make sure it works for all of us, both us as businesses and our employees. I'm just going to hand over to Richard now just to cover off sort of the legal aspects around this piece.
Good morning, everybody. My name is Richard Duval from IBB Law. Thanks, Lee, and thanks, Neil. So as Lee said, I'm going to look at the legal aspects of overseas remote working, focus really on some of the employment implications, some of the immigration implications, risk implications for health and safety, touch on data protection, and finally, hopefully give you some practical steps for you to look at to put a plan in place. So moving on, please, Kevin, and moving on again, please, Kevin. Context is everything, and Lee and Neil have already mentioned it to some extent. Brexit has obviously happened, and as of the 1st of January this year, freedom of movement between the UK and the EU came to an end. The UK has introduced a new points-based immigration system that treats all applicants equally, regardless of where they come from, so regardless of whether they're from the EU or a non-EU country. We're, of course, we're still in the midst of a global pandemic where people have been stranded overseas, and in many cases across the world, people have been required to work from home for the best part of a year now. In the early months of the pandemic, employees have found themselves working in different jurisdictions, often due to emergency measures. As times pass, we've seen technology enabling employees to perform their roles without geographic limitation. And it's now there is the potential for many thousands of UK-based workers to contemplate asking to work in their current job from an overseas location. It might be in their home countries to be near relatives, or they may just simply take the I can work from anywhere approach and look to work from a holiday home, or from the beach, or any other country that they fancy living in. But of course, there are a number of legal and practical implications that arise from that, and that's what I'm going to focus on today. Some of the employment implications. What employment rights will an employee have overseas? Will the employee retain their UK employment rights? It's quite possible that employees who work remotely in an overseas location may be entitled to benefit from local employment protections in the country they're living in simply by being physically present there and they're conducting work there. And those employment rights, they may be more generous than the entitlements they have in the UK, but you as an employer will still have to honour those rights. So for instance, an employee may be entitled to more annual leave, holiday pay, sick pay, enhanced maternity leave, and perhaps there'll be greater entitlement on termination of employment. As Lee mentioned, a lot of this stuff, and I'm going to be repeating this quite a lot as I go through my special seminar bit, is that it's all very fact specific on the particular country involved and what the particular individual is going to be doing in that country, where payroll is paid, what work permits are held. So you will need to have a look at it on a country by country basis. If an employee is looking to perhaps move into an EU member state, then EU laws on mandatory rights could provide an employee with the benefit of claiming the best of both worlds, where a mandatory law in the country they're living in offers greater protection than the laws here, then the more beneficial law will apply. It's also possible that EU laws may determine which courts have jurisdiction to resolve any dispute that may arise. You should look at whether or not you may need post-termination restrictions, so new restrictions or restrictions to protect your confidentiality, confidential information. Typically, where someone is on a UK contract and they're a key or senior employee, they will be subject to post-termination restrictions. For example, preventing them from accepting orders from a customer or soliciting employees for a competitor. And often there will be provisions which prohibit the use of your confidential information and trade secrets. It's important to look at and ensure that those restrictions you may have now will actually work where someone has moved to an overseas remote working position. Are they going to be enforceable in that particular country? Are they relevant where people are dealing with customers, suppliers, or confidential information outside of the UK? So again, you need to look at it on a country by country basis. In some countries, particularly European countries, you need to make a separate payment, must be made for the duration of any restrictions in order for them to be enforceable. Even though restrictions may be enforceable in the UK or under a UK law, they may not necessarily be enforceable against the employee in the English courts. So again, in EU member states, typically will say that an individual is only subject to proceedings in their country if the individual is considered to be domiciled there under that particular country's laws. Even if you could take proceedings in an English court and you do so, you get an order enforcing a post-termination restriction, it may not be possible to actually enforce that order in a particular jurisdiction, because in that country the restriction you've relied on infringes local principles of restraint of trade. So depending on the particular situation, it may be sensible to put in place new restrictions which actually take account of the law in the particular country where the employee is looking to go to live and work. You should have a look at whether or not you need to use local contracts of employment, whether that's the most appropriate contract to be put in place. It very much will depend on the type of work that's been undertaken and the length of time that an employee is proposing to be overseas. If they're going to be there in the shorter term, so sort of a secondment type arrangement, then typically what happens is you would maintain the UK employment contract and then you'd have a separate secondment letter to cover the period of the assignment. That will be particularly appropriate and the right thing to do if the intention is for that employee to return to the work in the UK, if they're going to continue to receive UK benefits and indeed remain in the UK social security system. If you're looking at a more longer term arrangement, then it may make a lot more sense to put in place a new contract of employment, which is subject to the local law where that individual is going to be living and working. In certain jurisdictions, it will be necessary to translate a contract or have a contract of employment in the local language. Sometimes in certain jurisdictions, if you don't do that, the contract will be considered void, which is obviously not very good. Where you are in those jurisdictions, but you still want to have an English version of the contract, that's fine. And the suggested course of action is that you would have a dual language contract in both English and the language of the country in which that person's living. You need to check whether or not in the particular country we're looking at, there are any working reimbursement requirements. Many countries around the world now do have or do require reimbursement of reasonable costs associated with home working. So for instance, in France and Germany, they will typically require the reimbursement of costs related to home office setup and maintenance of things like the internet. In Switzerland, they require the employer to make a contribution to an employee's housing costs, which could be quite significant. Please also be aware that you may inadvertently trigger notice or consultation or consent obligations in a particular country. Where you're changing someone's place of work, then you typically require someone's express employee consent to do that. Certainly that's the case here. Obviously, where someone is requesting to go and work from overseas, you are likely to have a problem with obtaining their consent to the change. But I think you need to be particularly aware, if you've got a temporary arrangement perhaps where someone is currently working overseas or going to work overseas, remote working, particularly in the current situation with the pandemic, but ultimately that temporary arrangement becomes a more permanent arrangement, then that may trigger those consultation requirements as to a change of a place of work. So please be aware of that. And you'll need, again, to review local legal requirements in a particular country where someone's going to be there for the longer term. If I may, can we move on, please, to look at some of the immigration implications? An employee who intends to work in another jurisdiction will need to satisfy that they're able to do so without any form of special permission, such as a visa or work permit, or alternatively, that if they're a citizen of that country, they won't have a problem, hopefully. Around the world, there are countries have visitor type visas, which will often allow for limited business activities, but the activities that are allowed are very narrow normally, and they don't usually allow for any form of productive work. So if someone's planning to be or going to be working remotely overseas for a long period of time, it is very unlikely they will be able to rely on any visitor type visa. If you end up in a position, or the individual ends up in a position where they have contravened the local immigration laws, then they can have very serious consequences for that individual. They may end up with a travel ban. It can also have very significant consequences on the employer, on you, both legally and from a reputational point of view. It could result in civil or criminal liability, and it could also have a negative impact on others. So if you have a number of people working in a particular jurisdiction, one ends up with a travel ban because they breach immigration laws, that could impact negatively on others who are also working in that country. And in the future, it may prevent you from obtaining work permits for that particular country. So it needs to be looked at very carefully. When you're looking at a particular country and it looks as though you do need some form of work permit, that in itself may be a legitimate reason to say to that particular employee, look, unfortunately, we can't let you work in that location because there is a work permit consideration that we have to take into account. It's also important, I think, where someone is moving overseas to look at the immigration position for any possible return to the UK. So with the end of free movement, EU citizens should consider, if they haven't done so already, whether at the moment to secure settled or pre-settled status before they perhaps return to their home country or indeed move to another country. If you're a non-EU citizen, they need to be crystal clear what impact any absence from the UK would have on their current visa status. If they've got an aspiration to apply for indefinite leave to remain or naturalisation as a British citizen in the future, then absences are assessed and will be taken into account. So they need to make sure that they don't inadvertently deny themselves that option in the future, if that's what they want to achieve. If you're currently sponsoring someone in the UK to work here, and they are going to spend a significant time outside of the UK, then that in itself could invalidate that particular sponsorship. It could jeopardize that person's ability to come back into the UK. It's likely to trigger any form of time outside the UK is likely to trigger a requirement on you to notify the Home Office of a change in circumstances. So please be aware of that. Kevin, can we just move on, please, to have a quick look at risk assessment? By that I mean health and safety and having a look at your company insurances. Employers have a duty to do all that is reasonably practicable to protect the health, safety and welfare of their employees. And that includes taking all reasonable steps to provide a safe workplace and a safe system of work. And those duties, they will extend to employees who are working remotely, including from overseas locations. It would be extremely sensible to, where you are looking perhaps to have someone working remotely from overseas, to carry out a home working risk assessment, to identify any risks in their setup and to minimize those risks. And of course, you also need to be aware of any local health and safety legislation which may be applicable. That legislation may provide greater protection or put greater onus on you than perhaps the health and safety obligations in the UK. Insurance, please check that your company insurances, so group income protection, death in service, travel insurance, private medical cover, are not impacted or invalidated by someone working overseas, and that they do adequately cover someone working overseas. So please have a chat with your insurance brokers or benefits brokers who hopefully will be able to help you with that. Please, moving on, data protection, data security. It could well be that someone moving to a remote working situation, that could create a whole host of data protection issues, because you may end up with personal data being transferred across borders between the employer and the employee. So it's really important to ensure that you've got the appropriate safeguards in place in relation to the transfer of data. It'd be worthwhile actually properly understanding what personal data that particular employee may possess. You need to have a look, as Lee said, at your policies, your data protection policies and procedures. Are they adequate to address employees working overseas? You may need to update your privacy notices, and it may be that it makes sense to provide further training. On the data security side of things, and I guess this goes for remote working, be a person overseas or indeed in the UK, that might present a greater data security risk, increased risk of hacking and cyber fraud perhaps, Wi-Fi network or system not quite up to standard, or the same as you may have it in an office environment. Now, I don't profess for one moment to be an IT expert, but I certainly know it will make sense to review your security practices and decide whether they're adequate or not. And if they're not adequate, you may want to look at putting in place things like virtual private networks and remote desktop protocols, but many of you may already have those in place. Moving on, please, Kevin. So lastly for me is I'm going to take a quick look at some practical steps and some suggestions that you may wish to think about. It is likely that any request from an employee to work from overseas is going to have a significant emotional undercurrent to it, particularly where an employee has got a compelling family or personal reason to want to work remotely from an overseas location. So it's important to have in place a clear strategy to help manage expectations, help with your decision-making process, and hopefully in doing so, that will ensure fairness and consistency across your business. From what I'm seeing, companies are taking different approaches to overseas remote working requests. A blanket approach of declining requests, it may seem like the easiest and fairest solution, but that can result in an unfair outcome for an individual. It could even lead to an indirect discrimination claim. Some companies are electing to allow international remote working on a temporary basis only. Others are looking at full remote working, doesn't matter whether it's in the UK or anywhere else in the world. Some have made a policy decision not to allow employees to remote work from overseas at all. If you are minded to allow remote working internationally, then as I said, it needs to be carefully planned. So you're ensuring that you're fulfilling both your business and your employee needs and all of your compliance obligations. So I would suggest that as part of your planning and strategy process, you establish clear objective eligibility criteria to ensure consistency, minimize that risk of any discrimination claim. Some of the criteria that you may wish to include could be looking at the nature of the employee's position, whether their job duties can be performed remotely. You may take into account someone's seniority or tenure with you, the availability of supporting technology, and you need to think about data privacy and cybersecurity issues, as well as the actual person's working environment at home in that overseas location. I'd also suggest having a plan in place to monitor headcount in a particular location. Where you've got more than one employee in that country, certain obligations legally can be triggered by hitting a certain number of employees being located there. So for instance, discrimination laws may be altered or triggered by it. Collective consultation requirements and termination of employment entitlements may depend on how many people you actually have located in that particular country. And that in itself may have a bearing on your willingness to allow a particular person to work in a particular location. It's, I think, very helpful to, at the outset, set an employee's expectations. You should have in place a process for how you receive and consider an overseas working application. Employees should be required to ask permission first before working overseas. And they should be and understand those eligibility criteria that I mentioned earlier. I also think it's very important to put in place and document in a written agreement the terms of any overseas remote working that you may agree to. And in that written agreement, you should give yourself, I would think, as much flexibility as possible to terminate that arrangement if the business needs to, and require those employees to return to the UK as you may need from at any point. And lastly, from me, before I hand over to Carol, and I think Lena mentioned it as well, please have a look at your policies. You need to clearly communicate to your staff what is and what isn't acceptable in terms of remote working. And you need to look at your policies to work out whether they adequately cover the supervision, performance management, time recording, issues of confidentiality and privacy as they currently stand, or do they need to be updated? If you put in place those clear policies, then hopefully that will allow employees to fully understand what is expected of them, and hopefully that will ensure consistency across your business. So at that point, I'm going to move on to Carol, or Carol is going to take over from me. Many thanks.
Great, thanks ever so much, Richard. Hi everybody, I'm Carol LePage. I am a partner at BDO, and I particularly focus on corporate tax matters and do a lot of international tax work, which is why I'm here talking to you today. I'm particularly going to talk about permanent establishment today. That is by far and away the biggest risk from having employees working overseas from home. And when I say permanent establishment, I mean a taxable presence of the employer company in the country that the employee is working in. So that can be completely independent of having any company or any other sort of legal entity set up in that country. I'm also going to touch on a few other issues such as corporate residence, indirect tax, etc. But the permanent establishment is the biggest risk. It's worth just to put things in context that there has been a lot of tax authority sympathy for the fact that people have been stranded overseas or required to work from home because of COVID. So there was kind of initial leniency, for want of a better phrase, around actually triggering any taxable presence as a result of that. And it fits quite nicely into the phases that Lee was talking about. But certainly the longer home working continues overseas, the bigger the risk. And absolutely, as you get into Lee's Buzz Lightyear phase, and there is that kind of shift in working patterns longer term, there is a definite risk that you could trigger some overseas taxes. Kevin, next slide, please. Actually, one more, please, as well. Right, so starting with permanent establishment rules, there are international tax principles really that are probably the best thing to look at here. There are typically two types of permanent establishment. One as a result of having a fixed place of business, and one if there is a dependent agent. So considering, say, a UK company with an individual working from their home in Denmark, let's say, you could have a fixed place of business of the UK company in Denmark if the UK company's business is being conducted through that individual in his Danish home or her Danish home. You could also have a PE if that individual in Denmark is actually concluding contracts for the UK company from their home in Denmark, or they're playing a very significant part. So are they convincing the customer to actually sign with the UK company is kind of a broad brush test there. There are some get outs from having a fixed place of business. Typically, if an activity is preparatory or auxiliary, that's the biggest relevant one here. And that's actually quite difficult to define, but tends to be where the individual is doing something that is not core to the business of the employer company. So it might be very far removed from anything that if you tried, you could attribute profit to, let's say. It's worth highlighting here that domestic law may be different. This is international tax principles as defined by the OECD that I'm talking about. So each country is different. Each country is going to depend on the facts, but a lot of domestic law does use this guidance to derive their local laws, and tax treaties tend to use this definition too to provide relief. So it's the best guidance that we've got. Next slide, please, Kevin. So the key question in this scenario, can a home office be a PE? Big question. First of all, looking at the fixed place of business type PE, there are clearly elements of that definition that need to be satisfied. So question one, is there a place of business? Question there is, for example, is it at the disposal of the employer company? So just because you've got somebody sat in Denmark, in my example, working for the UK company, it doesn't mean that their home office is actually at the disposal of the employer company. Does the employer company have a right to go in there? Does the employee have meetings there? What are the other arrangements that could kind of apply there? Are the home working arrangements such that they really become a permanent fixture as well? You then need to look at whether it's fixed. Clearly, a home office is a fixed place. it is fixed by nature, but actually for the purposes of this sort of test, there is a 6-month rule of thumb. So if somebody's only in a country for a couple of months or so, probably okay. But if they're there for 6 months or more, then that is definitely when you need to start worrying. There's also the point here that it can kind of be retrospective with a change of circumstances as well. So if you started having to work overseas due to COVID, but actually longer term it's going to continue, there is a risk that you could actually be looking back to that kind of COVID period as well when looking at what your PE profits actually are. So assuming you do have this fixed place of business, that the business of the, in my example, UK company is carried on through, question then is it preparatory or auxiliary? So what is that person doing from their office in Denmark? Is it really core to the business? You know, are they making sales or something, or is it actually something very, very remote from realization of profits? Like, you know, they might be looking at finding a provider of stationery or something. So how kind of core is it, and could it be preparatory or auxiliary? The dependent agent PE is quite an interesting one. For that to apply, you need to have habitual involvement in contracts. Habitual isn't defined. There isn't quite that 6-month rule of thumb, but it does effectively imply a degree of permanence, and similar tests do apply. So if you do have somebody who is involved just, you know, a little bit in contracts for a short space of time, you're probably fine. But if they're doing it longer term, then definitely need to worry. And the key here to point out as well is you don't need a fixed place of business for there to be a dependent agent PE. Next slide, please, Kevin. So continuing that example a little bit more, imagine you've got Fred working in Denmark, employee of the UK company. What sort of things do you need to think about in terms of deciding whether Fred is actually creating a PE? So number of questions on the slide that you can read through at your leisure, but there have been 2 cases in Denmark recently, which is why I particularly picked Denmark as my example. One was where an individual was working 1 day a week in Denmark, chose to do it on a Friday just to be with his family over the weekend. Otherwise, he was based in London. The conclusion there was that there wasn't a fixed place of business, there wasn't a PE, because he didn't do any contract work when he was in Denmark. It was very much a choice. There was no business benefit to the UK company of him being there. There was no sort of access of the UK company to his Danish home. There was a second case which involved somebody being employed purely for 6 months in Denmark. And this was actually for a German company. And that person was there just to test the water, really, in terms of whether there could be a market for the German company in Denmark. And they were working at home. And the conclusion was, despite the fact it was a bang-on 6-month contract, the home working was permanent and regular for that individual. There was nowhere else they could work from. And they are doing something that is quite fundamental for that German company, because they are really testing the water, and it could be a longer term thing. Does make you wonder, though, whether the facts, if they were slightly different, whether the answer would have been different in both cases, actually. But both cases and various other bits of case law over the last few years have been very clear that a home office can create a PE. It's very facts and circumstances specific, and I'll be interested to see what the direction of travel is as well, and whether things do actually adapt further for that kind of shift to more overseas and home working post-COVID. Next slide, please. So moving on, touching briefly on tax residency. Companies have a tax residence, just like people do. There are 2 typical tests under international domestic law, either driven by place of incorporation or by place of management. Clearly, place of incorporation not going to change. There's going to be no impact from COVID-19 on that element, but the place of management, clearly it implies where people are. Typically you look at board meetings for that, but again, it is very fact specific. So if the directors, for example, are suddenly having board meetings from other places, taking strategic decisions in different places to the past, it's worth bearing in mind that that can have an impact on your corporate tax residency. For corporate tax residency, it's a kind of journey, it's a story. It's not something that you're going to trigger quite as easily necessarily as a PE. A company can go on holiday and not change its residency. But if that direction of travel and into that kind of Buzz Lightyear phase is such that you are actually going to end up with a real shift in how the business is strategically run, then it's definitely worth looking at this to make sure that you don't have any unexpected tax charges. Next slide, please. Looking at some indirect tax aspects, the indirect tax rules are very similar to the corporate tax ones. There is a fixed establishment rule rather than a permanent establishment rule, and then looks at seat of management rather than that kind of management and control concept. They aren't the same as corporate tax, though, worth highlighting that. You need effectively some suitable structure and and kind of ability and resources, etc., within the Home Office to receive and use or supply the services at point. So there could well be, for example, a VAT establishment if you've got somebody who's very sort of autonomously providing some services from their home and don't really need anything else to be able to provide those services. Particular risks here include if you're selling to consumers or if you're part of a partially exempt supply chain, particularly because you could end up with some loss of tax there. But it's worth bearing in mind, you can't say I have no corporate tax PE, therefore I have no indirect tax establishment. They are slightly different, albeit there is that overlap. Next slide, please. Looking at a few other issues, I'm going to particularly pick up on the transfer pricing piece on this slide. And it's worth highlighting that if you do have a PE somewhere, it's not necessarily going to be a disaster. It doesn't mean that all the profit to do with, say, some big contract that Fred signed in Denmark, in my example, is suddenly sucked in and taxed in Denmark. You actually have to look at the overall picture connected to that actual profit and that kind of contract that Fred signed, and work out how the profit pie needs to be split up and what would an independent person earn doing what Fred has done in Denmark. So it's not necessarily a disaster at all, but of course it does come with compliance pain and the need to actually kind of look at it, and it is definitely an art, not a science. It's also worth pointing out the audit point here, and again Neil touched on this right at the start. Very much a point that if you do have a lot of these people working, a lot of employees working from overseas offices, then you could potentially have some sort of audit risk coming from this. You could have some sort of material exposure. So you need to be able to evidence to the auditors how you're managing it and how you are comfortable that it's okay. And also just thinking about whether you've got any uncertain tax positions as well. Next slide, please. So just to wrap up from me, what do you need to do now? So you need to work out where you are today. And by that, I mean, do you know where your employees are working, how long they've been there, what they're doing, how long they want to stay? You can from that get a real flavour for whether you potentially have an issue now. Are there any operational changes that you might need to make in the short term while you sort out your longer term policy? You know, what position are you in at the moment? Then you need to think about what commercially do you want to do? You know, these things shouldn't be a tax decision, they're a commercial decision. So there is the question of, do you want to just allow the flexibility because commercially you have to, you need it for talent retention? Do you want to let people work from anywhere and you will just get them to tell you, apply to you effectively for permission in advance and you're going to let that happen? Or are you going to take a very hard line and say, everybody back to your home country by this date, which certainly one multinational I'm aware of has done. It's also a question of how are you going to run your business going forward as well. I've had conversations with a couple of clients who are thinking about going fully remote and just shutting their offices because the offices are coming up for renewal. So that again would move the goalposts and potentially increase the risk if you do have people working overseas as a result of that. You need some protocols, parameters for your employees too. So are you going to permit everybody to ask to be able to work overseas? Will it be certain grades? Will you permit certain countries? Are you going to whitelist somewhere? Are you going to set up companies in 3 or 4 different countries because that's actually where the vast majority of people want to actually work? How are you going to manage this? Are you going to permit very short-term trips but nothing long-term? It's all a question of what's going to work for you and your business. So overall, there is unfortunately no one size fits all, and it is very much dependent on the facts and circumstances of your case. But the key is that you want to be aware of what's going on and make sure that you can proactively manage what's going on, manage your corporate tax risk so that you don't end up with any nasty surprises. So on that note, I'm going to hand back to Neil to wrap up.
Thank you, Carol. So some really interesting insights from our speakers. So just very briefly, just going back to Lee's presentation, it's clear that knowing where employees have been historically and where they will be going forward is vital, so that so you can respond to dealing with historical issues, but also plan and be compliant for the future. In terms of the legal implications highlighted by Richard, it's clear that the more that we have employees in different countries, it's going to create additional complexity and considerations to work through. And while the topics might be similar in each country, the answers won't necessarily be the same. From Carol's perspective, for corporate tax and indirect taxes, the presence of employees overseas will increase the risk of creating taxable nexus. Therefore, business is going to need to look at the local rules, but also what the employees are actually specifically doing. Are certain controls or restrictions on what they do required in order to reduce the risk of creating taxable presences overseas? So next slide, please. So as I said at the beginning, to maximise the opportunities and manage the risks that come with more international remote working, businesses will need to develop a strategic plan around this. So while not exhaustive, some of the key stages of this plan I've just set out on this slide. And as you'd expect, it starts with identifying risks and priorities, but it then includes engaging with the key stakeholders to reach a consensus to help formulate what the appropriate policies should be. But having strategy is only part of the process, really. There's a subsequent execution, monitoring, and adaptation of that strategy so that it remains relevant going forward over the years. This is going to involve sort of tracking where employees are and what they're doing and putting the relevant controls in place. So next slide, please. So questions. So we've had many questions, and some of them we've managed to answer through the chat function already today. But I'm also conscious of time here, so I'm just going to pick on a small handful of questions that we've had through that perhaps sort of represent sort of some of the generic type themes that we've seen. And what we will do after this is look to address many of the other questions in a circulated sheet, because we've had many questions. I think it'd be really good for us to respond to as many of those that we can. So just thinking here, I think this is probably a question for Lee here, and it's one that's sort of come through this morning. And the question, Lee, is, so if I work in the UK for one day, I think I understand that we are liable to pay tax on that. Is this not treated as business travel and managed in that way?
Yeah, it's a question I honestly get asked many times every single year. We need to think about basic principles here, and I'll go back to something I said in my session: is you pay tax where you work, even for one day. So as a starting point, if you come into the UK to work for a day, you are liable to tax on the income you earn for that day. That is your starting point. You then need to look at the tax legislation, law, guidance to see, in reality, is there a way that ultimately we can get out of that tax? Obviously legally, but we can get out of that tax using the law and legislation that says, no, you're not going to pay tax in the UK for one day. That would just be a ridiculous amount of admin. It would cost us more to collect the tax than it would for the actual tax take that we get from it. So this is where I was talking about this agreement with the revenue and tracking of employees coming into the UK. I would say 99.9% of those individuals that come into UK, I would consider genuine business travellers, so a handful of days a year. They're probably not going to be liable to UK tax ultimately. They're almost certainly, if they're coming from a country that the UK has a double tax treaty with, they're probably almost certainly exempt from UK tax. But you have to put the agreement in place, track them, and then do the reporting year end to HMRC to one, demonstrate to HMRC that you are tracking your employees, that you know the number of days they're spending here, and that where they may actually trigger a tax charge, that you're going to pay that over. But also so you can then provide the information needed to HMRC to show for those visitors that have come into the UK where they're exempt, why they're exempt from tax. So I would say the starting point you have to remember is you are taxable, and then you see how you can obviously legally unwind that and use the tax legislation to ultimately say to HMRC, no, tax is not due. But you can't just make that decision without the tracking and reporting element.
Okay, no, thank you very much, Lee. A question here for Richard, please. A Spanish national currently working in the UK on a pre-settled status until 2024 has suggested working remotely from Spain. Is there any sort of thoughts there, Richard, around some of the considerations that need to be thought about there?
Thank you. Yes, I suppose that the main one would be the impact on the person's pre-settled status. The current position is that you can spend up to 2 years outside of the UK without losing your pre-settled status. But if you're looking ultimately to obtain settled status, then you need to show some form of continuous residence in the UK throughout the period. So I think the requirements are, one, you would need to have spent 3 years continuously in the UK before you go to Spain, and you need to come back to the UK throughout the time you're away on a very regular basis. So it could have a negative impact on settled status application down the line. And then the sort of employment aspects of it, I think I mentioned, are Spain, I think in October, has introduced a new legislation around responsibility for employers to provide home working equipment, etc. And as I said, it's just a question of really looking at and understanding what mandatory Spanish law may apply to that individual whilst they're there.
Okay. Many thanks, Richard. I think we've got time for a couple more questions. So I think, Carol, this one might be one for you to respond on, please. So we are using 120 days as a maximum time per country within their company as a general guideline for this employee sort of resident spending time there. If there are more employees going to the same country, is it important to keep track of their number of days?
But certainly from a corporate tax perspective, yes. One of the points I didn't mention, actually, I think it was alluded to on one of my slides, is there is a real direction of travel at the moment in terms of actually looking at what an entity has in country as a whole, or what a group has in a country as a whole. So if you have lots of individuals, for example, you might have somebody going out for 120 days to France, let's say, and then there might be somebody else going out for another 120 days to France, both working from their own home offices. You actually have to potentially look at everything. There is a direction of travel in terms of trying not to allow businesses to what they call fragment activities into different locations to avoid actually having any location that creates a permanent establishment. So I think it is important to make sure that you've got the overall picture certainly from a corporate tax perspective, and I imagine from a wider perspective as well.
Yeah, I think I'll just add to that as well, Carol. 120 days is quite a high bar from a personal tax perspective as well. I appreciate companies do want to try and operate on sort of a rule of thumb, and I completely understand that. I would say that if you're going to try and use a bar, I'd bring it down quite a bit below 120. I think you could be triggering liabilities well before you hit that threshold, to be honest.
Okay, no, thank you, Carol. Thank you, Lee, there. So I'm just conscious of time here. So as I said, I think we had many questions. What we'll look to do is to answer as many of those as we can and circulate that as a answer sheet after the event today. So I'd like to thank you very much for attending, and hopefully you've gained some really useful insights. The contact details of all the speakers today are shown on the screen if you'd like to follow up any of the points raised. As I say, a recording of today's presentation will be circulated to everybody that's attended today, but we will also post this on our website as well, so you'll be able to send links to anybody else that you know that you think would really value having the opportunity to hear what we've talked about today. So on that note, I'd like to say thank you very much for joining us. Take care, stay safe, and we look forward to speaking with you all again soon. Thank you.